It's kind of odd that we should begin the conversation with law, right? Because law is usually the tail on the dog, and that's the appropriate place for law here. Nevertheless, it's interesting that as AI hit the scene worldwide, that the first conversations really concerned the dangers of AI, and now we're into a stage when there have already been a number of class action lawsuits filed against the large AI players, Google, OpenAI, and others. So it's probably worthwhile at least disposing of kind of these legal risk issues right up front, especially for startups, because startups are in a fragile time of life for a company. If you're in a startup company, and you really want to make sure that you have the foundation right, and that you're not early on, when you can least afford it, exposing yourself to the kinds of risks that would be endangering your business. So in thinking about risk assessment, legal risk assessment for startups, it really comes in two dimensions primarily. One is the use of AI as a tool in the conduct of your business, and the other is the use of AI as a product or as part of a product that you yourself are offering. So let me talk first about your use of AI as a tool. Here, it's the legal issues are really not different in kind from any other tool you might be using in your business, right? Any other kind of information that you're relying on, any other kind of software that you're relying on, it's very, very similar. And so the kinds of concerns you really ought to have in using AI to, say, respond to customer requests, or to provide feedback to customers, or to manage customers, or to help to build your product, the concerns really go to your need to provide due diligence, your need to inspect what the AI is coming up with as part of your response to your customer or to your partners. So if you're in a position of trust, in particular, whether you're maybe in healthcare, in law certainly, but even in education, in finance, if you're using AI as part of the process for responding to customer requests, you really need to get in and use due diligence. And as a matter of fact, there's a kind of case in point here that occurred a couple of months ago, where a lawyer was providing a brief to a court, and used OpenAI, used ChatGPT to construct his response. ChatGPT came back with what seemed to be a very certain answer to the question, and it even supplied citations to that lawyer's memorandum in support of his brief. And the citations didn't exist. The law wasn't real. And the lawyer was subsequently sanctioned by the court for using that without exercising any kind of human judgment, human intelligence for the oversight of his answer, right? Another thing that you need to be careful about when you're using AI as a tool is keep in mind that all of the tools that exist so far are not local. They're not running at your machine. They're running in the cloud. So any information that you provide as part of the formulation of an answer or response to your client, that's being uploaded to OpenAI's cloud. And that's being uploaded to Google, to Bing, and others. So you really want to keep company information, proprietary information, personal information out of any interaction with these AIs to the degree possible here, because you've lost control of it the moment it goes up there. As a matter of fact, if you look carefully enough at what OpenAI calls out in its own legal terms and conditions, they have a right to the use of that information. So you may potentially have forfeited any proprietary rights or any privacy that you have by providing that information as part of your inquiry using that AI. The third piece here is what I call provenance, what I call introspection. So in other words, if an AI comes up with a conclusion to an answer that you raise of it, your ability to ask it, how do you know that? Or ask it, how did you arrive at that conclusion, is really pretty limited, because its own ability to introspect on its own, call it chain of logic, is pretty limited. And so you really want to carefully consider whether what it's providing you is a conclusion, and if so, what that conclusion might be predicated on, because you're not going to have the ability in most cases to say, how did you get there? How did you arrive at that conclusion? You may need to, in many cases, iteratively ask it further and further questions based on the answer that it supplies. So that kind of covers the set of considerations for a startup having to do with its use as a tool. The second piece here, and I want to get through this quickly, forgive me for going on at length, really concerns if you are a startup using AI as part of your product, or indeed if an AI is part of your product, if you have a large language model or even a limited language model that you're using as your product for the market, you want to consider fundamentally three things. One is the contractual relationship and the business relationship that you have on the supplier of the AI. Second is, again, third-party information. The use of that AI where you're relying on the information that it's built upon, the information that it was trained upon. And the third has to do with product liability. Let me race through these real quickly, and then I'll be quiet because we need to move on. One is the reliance consider the reliance on the supplier. If you're building a product, you're in a contract with OpenAI, you're in a contract with Google and their LLM, and you're building using their APIs. Consider the fact that that introduces a lot of contractual and business risk. If something goes wrong, take a look, see whether you can look to them to backstop you, or, so to speak, indemnify you for what it is you're relying on them for. In most cases, the answer is you're not going to be able to rely on them. And in most cases, the answer is they can change or withdraw that product at will. So, and they can do that based on the contract they have with you, which more often than not is a click wrap, right? More often than not says that by supplying my username and ID and clicking on the button OK, I assent to these terms and conditions. We never read the terms and conditions, but be careful what you're signing up for. Another issue here concerning that same issue is consider the intellectual property risk, because those same providers may have rights to inspect what it is you're doing here. And if you're developing something that you think is a proprietary product, consider that by using their product, you may have volunteered trade secrets to them. You may have volunteered methodologies that you had hoped to keep secret, and thereby, gain proprietary rights, but you may give those up as part of the contract with them. Another piece here concerns your use of third-party info. Let's suppose that that you're offering a medical AI, or in my case, a legal AI. Well, again, as in using it as a tool, if you're using third-party info and volunteering third-party info, consider the privacy and confidentiality concerns here. And to the degree that you're using proper names, to the degree that you're using personally identifiable information, to the degree that you're using intellectual property belonging to third parties, that exposes you to a good deal of risk. And indeed, if you look at all of the court cases filed, and there have been many over the past 6 months, beginning in January, beginning shortly after OpenAI made its announcement, artists galore have come forth with primarily copyright lawsuits against these people, saying that you've copied my script, you've copied my book, you've copied my images, you've copied my movies, and therefore you've infringed my copyright. Now, I have personally some qualms with that legally. I don't think that many of these suits are terribly well founded, and I won't go into that right now, but nevertheless, that's an exposure. And your customers may come at you for exactly the same thing, even if you're using OpenAI and their APIs as the mechanism for supplying whatever service you're supplying. Finally, there's this issue of product liability. And product liability goes to, in part, to your negligence, but in law, especially in the United States, it's pretty well settled that in many cases, there's something called strict liability, where if something goes wrong, it doesn't matter whether a court finds you negligent in providing this service. You can sometimes be held strictly liable for any bad consequences here. And as AI matures and as it begins to offer what are called function calling, for example, where it's not merely the exchange of a conversation, but if your product is using function calling to, let's say, control an automobile, let's say, control other programs that may have to do with social media or may have to do with background inquiries on people, the AI is going to become increasingly powerful, not only in providing conversation to you, but in making things happen in the real world. And that can introduce strict product liability in some cases for what you're offering. If something goes wrong or something goes out of control, and your ability to control things may be severely limited. So I hope that provides a good overview, and I hope I haven't gone on too long. Louise, back to you. Thanks.